Hi everyone, I'm Tom Fitton, Judicial Watch President, with our weekly update here on Facebook, YouTube, and Twitter. Thanks for joining us today. A lot to talk about this week. More outrages on the mishandling of the Clinton email investigation, new lawsuits from Judicial Watch, also a new key court ruling in our effort trying to get the Clinton emails that are still potentially out there. First up is the latest outrage out of the era of Jim Comey's reign as FBI director. There was a letter sent by Chuck Grassley and Lindsey Graham, two Republicans on the Judiciary Committee yesterday. They sent it to the new FBI director, appointee of President Trump, Mr. Christopher Wray, and the letter details new documents that that committee had received from the Justice Department and the Office of Special Counsel, detailing the fact that Mr. Comey may have prejudged the Clinton email matter even before the investigation was finished. According to these new documents, there were interviews done by the Office of Special Counsel, which is a separate agency that investigates whether there was improper political involvement by public officials, and the left had complained to the OSC, I recall, that James Comey's intervention or statements about the Clinton email matter were improper interventions. So they did an investigation, I guess closed it. But they did interview Comey's chief of staff at the time and one of the top lawyers in the FBI who worked for Comey as well. And they asked them both when he began creating the statement that was ultimately read in early July, and it turns out that he began working on it in April and May, 3 months earlier than we, I think, have been led to believe by pretty much everyone, including Mr. Comey, under oath. According to the document, they say, who is the lawyer who says this? Yeah, his chief of staff says he began working on it sometime in spring. I don't remember exactly when. The director emailed a couple of folks, and then May of 2016 was when he recalled that it was sent out early May 2016, or early April, or excuse me, April or early May. And the lawyer who was interviewed said that the idea to make a statement was in early May of 2016, and Comey wrote a draft of that statement. And so essentially the thinking was they knew how it was going to turn out, and they were going to do this statement exonerating or recommending no prosecution of Hillary Clinton. Now, what hadn't happened by then when he began drafting this statement exonerating Hillary? They hadn't interviewed Hillary Clinton. They hadn't interviewed a total of 17 witnesses, including her chief of staff, including her IT people, 17 witnesses. And many of those witnesses, as you know, outrageously were given broad immunity agreements. And if you want to know why now they were given immunity agreements, why they were handed out like candy, it's because evidently there was no real investigation. They weren't intending to prosecute anyone. So why not hand out an immunity agreement? And as this letter points out, Katie Pavlich broke the story over on townhall.com yesterday. Remember, these immunity agreements included agreements to destroy evidence. If they got laptops, they would destroy the evidence. So really outrageous conduct. And it calls into question Comey's testimony, because he suggested that he made the decision to exonerate Hillary, not recommend prosecution, in July. And it was related to the tarmac meeting that had happened just a week earlier. Well, that wasn't the case. He began drafting his get-out-of-jail-free card for Hillary Clinton in April or early May. Don't take my word for it. It's the sworn testimony of his aides. And of course, Comey isn't commenting on this, as best I can tell. He misled, it looks like, the American people when he testified otherwise. Now, his testimony, I'm sure, has caveats. I'm sure there was wiggle words, but it was misleading. because he made it seem like he made the decision while after all the facts and evidence was gathered. And that was not the case. Really outrageous. And I tell you what, if I were President Trump, I would order the Justice Department, and this confirms that this sham investigation was rigged. I would order the Justice Department to relook at all the Clinton material, Clinton emails, how all the Clinton investigations were handled by the prior Justice Department and FBI, and figure out whether they need to restart them. Or they need to make sure, given the deep state's antagonism towards holding Hillary Clinton accountable, that if there are any investigations, that they have the proper resources and they aren't being suppressed. Because I fear that's what's happening. Because the Clinton email matter is not closed. Now, they shut down the investigation into the handling classified information. But remember, there was a referral to the Justice Department after that over whether she testified truthfully. And supposedly there were independent investigations in various U.S. attorneys' offices and within the FBI into the Clinton Foundation pay-for-play scandals. Are those investigations still ongoing? What's going on there? But I tell you, the Justice Department needs to commit itself publicly to accountability and making sure the American people can have confidence that this investigation was handled in an apolitical manner and without someone like Comey, who is as political an FBI director as anyone, without his thumb being on the scale. And this isn't even talking about the Loretta Lynch, Bill Clinton tarmac meeting, which also cast a cloud over the Clinton email investigation. So this is a pretty serious event, pretty serious disclosure. The big media, you can bet, is going to try to downplay it and minimize it, but it deserves more attention. And I was on Fox News yesterday. I was on both Fox Business, Lou Dobbs' show, and then Tucker Carlson's show over on the Fox News channel. So I encourage you to go back and look at my appearances there. I probably say pretty much the same thing, but I only have a minute or two to say it. So you get the full Tom Fitton when you're watching the weekly update here. So that's an important topic. We're on it. And I tell you what, when you look at the way Comey treated Hillary Clinton with the targeting and outrage related to Donald Trump and the focus on him, I tell you, justice was so politicized, and frankly still is, given the way things are going during that campaign. And as I told Tucker yesterday, the true interference in the election systems and our elections wasn't from the Russians. I'm not saying they weren't involved, but the most significant interference, and something we should be able to do something about, was the FBI and Justice Department protecting Hillary Clinton and targeting her opponent, Donald Trump, in the middle of the campaign. And the targeting of Trump hasn't ended, and it's improper and inappropriate. And along those lines, we had asked for, and this shows you why the challenge is so significant even with the change in administration. Now, you remember this so-called dossier, the dossier, the Russia dossier that was created by this firm that has ties to Democrats, ties to the Russians. The big media will tell you there's some Republican donor who paid for it. We don't know who that donor is. It's never shown up. But it's pretty clear that this dossier was dodgy and was unsubstantiated. And but what's outrageous is the FBI was using it, and arguably still is using it, based on reports, to investigate Donald Trump. So this is just political smearing, opposition research being turned into an FBI criminal investigation into the President of the United States, and it was used as an excuse to target Trump and maybe even surveil him and his team last year. So outrageously, the FBI was reportedly paying the authors of this political opposition research document money. You heard that right. The FBI was paying the authors of the Trump dossier. So we asked for documents about that. And we also separately asked for the dossier itself to see what went on. Now, supposedly John McCabe received a copy of it, and The FBI abroad received a copy of it. So why can't we receive a copy of it? What's in there? Because they don't want to release it, as you might imagine, because it will expose the document for the fraud it evidently is. But the FBI, under again Donald Trump and his appointees, has told us we can't get the document, and they're not telling us that. They're telling us they can't confirm or deny the document exists. They can't confirm or deny the Trump dossier, which you have probably heard of, exists. Talk about Big Brother doublespeak out of the FBI. James Comey testified about the dossier. Yet the FBI then comes and tells us that if they were to confirm or deny it exists, it would confirm something that would be related to national security and foreign intelligence functions. We already know they're investigating the Russia involvement in our elections. So what's the news there? And they would confirm that it's they don't want to acknowledge the existence or non-existence of a pending investigation that had not been previously acknowledged. As I said, Comey testified about this. And he did it presumably with the approval of Robert Mueller and the Justice Department. But I'd like to know who in the FBI is making decisions like this. Who in the FBI is making decisions like this? And why isn't Jeff Sessions and now Christopher Wray riding herd on these bureaucrats in the deep state who are telling us no? We are battling this administration's people in this administration who presumably are answerable to the President of the United States on these key issues of transparency in government and battling corruption. And we received good news yesterday from a court appointed by, ironically, President Obama, if I recall. And again, this is one of Judicial Watch's legal battles. We're trying to get the Justice Department or get the State Department to initiate action as the law requires with the Justice Department to go and get the emails Hillary Clinton took improperly. They know the records went missing, and they're obligated under the Federal Records Act to make sure the Justice Department initiates action, or at least to tell them about it and ask them to do something. Now, it's no surprise the Obama administration didn't want to do that. But can you believe the Trump administration's appointees in the State Department are battling us on this? Well, that's what's happening. And in the course of this court fight, so what happens is the State Department goes into court. They're represented by the Justice Department. And the State Department's trying to tell the judge, look, there's nothing else we can possibly do to get Hillary Clinton's emails. And to that end, they filed a declaration by the FBI telling what they've done. But the problem was that declaration was filed in secret, or in camera and ex parte. So it's just given to the judge to read and not to Judicial Watch. And so as a result, we're fighting a phantom. How can we argue that nothing was done or sufficiently done to get these emails if we don't know the document? And so yesterday, the court ruled against appointees in the Justice Department and State Department of President Trump that no, they're going to have to release this information. Now, the Trump administration had said it had referenced grand jury information, and the judge was buying none of it. He said all of this stuff is public, and to the degree there's something that may not be public, you can withhold it, but you got to release it by and large. So we're pleased by the court ruling, but I am upset by the fact we had to achieve that court ruling after fighting this Justice Department and State Department. And again, this is an instance where you've got the deep state opposing efforts to disclose information about Hillary Clinton and disclose information, frankly, that would probably be helpful to shutting down the fraud criminal investigation into Donald Trump. So the court ruling is available on our website. But this shows you how difficult things are, even with the new administration. And I can imagine the president is outraged, and he ought to be outraged that his appointees continue to protect Hillary Clinton. And to that end, we sued. And this is a fun lawsuit, and it's an important one, because oftentimes when Judicial Watch goes to court to sue for records, we're representing ourselves. We ask for records, and if they don't give us the records within a certain time frame, or we don't like the withholdings they've made, or the redactions or blacking out of material, we can go to court. But other times we represent people who have also asked for records and aren't getting justice and aren't getting the records they're due under the law. And in this case, we're representing a retired FBI special agent. And his name is Jeffrey Danek. And Mr. Danek asked questions about Deputy Director Andrew McCabe's connections to Terry McAuliffe, a Clinton ally. And for those of you who don't know, Mr. McCabe was, I think, number 2 at the FBI under Comey. And the problem that he had was that his wife was running for public office, and she received, I think, a total of $707,000 from Terry McAuliffe and the party operation close to Terry McAuliffe. And McAuliffe, by the way, is a corrupt Clinton crony. He's governor of Virginia, but he's a corrupt Clinton crony. So his wife is running for public office, getting hundreds of thousands of dollars from this corrupt Clinton crony, who, by the way, was under FBI investigation. I don't know where that stands now. But McCabe didn't pull out or recuse himself from the Clinton probe. How did that work? Doesn't that seem like a conflict of interest to you? So Mr. Danek, the retired special agent, knows how to ask questions about his former agency. And he wants the text messages and emails of McCabe containing the phrases Dr. Jill McCabe, Jill, Common Good, Virginia; Terry McAuliffe, Clinton, Virginia Democratic Party, Democrat conflict, Senate, Virginia Senate, until I return, Paris, France, campaign, run, political wife donation, OGC email, or New York Times. Now, I went through that in detail to show you that the FBI has no excuse not to give Mr. Danek the records. And you can bet these text messages or emails are going to be enlightening to the public about what was going on with Mr. McAuliffe and the top official at the FBI. And Mr. Danek had a statement. I'll read you to it. I'll read you his statement. I am saddened by how the FBI's reputation has been tarnished by the poor judgment and ethics of its leadership. I know I'm not the only retired or serving FBI special agent who is concerned about Mr. McCabe's conflicts of interest on the Clinton email matter. The agency seems to be illegally hiding records about this scandal, which is why I'm heading to court with Judicial Watch. And so we're honored to be able to represent him. And we're so happy that others are also holding the government to account. And I tell you, he served this agency for decades, and when you have retired people willing to sue the agency, it shows you how the corruption issue is really damaging the FBI, which is so unaccountable in this town. It's frustrating, and so we're happy to do this work. Now, this is, I think, the 4th lawsuit Judicial Watch has filed with respect to Mr. McCabe. We have well over a dozen lawsuits now on this abuse and deep state targeting of Donald Trump and the conflicts of interest and related matters like that. And I tell you, there's no one else doing this. There's no one else doing this with in terms of the sheer volume, number of lawsuits, and I can't even tell you how many, because I don't know. I'd have to go and look in our database, how many Freedom of Information Act requests we have. Because we only file, one lawsuit perhaps for every 10 Freedom of Information Act requests we file. Now, that's a wild guess, but I think it's a pretty close one. So we are on top of this. And there are more coming about topics you care about, believe you me. So if there's something out there you're nervous about or worried about, and I know all the other scandals out there, believe you me, we track them all. We're asking questions on them, we're monitoring them, and when the opportunity arises and we don't get answers, we will sue in court. And we've demonstrated that time and time again, and we've demonstrated that when we take action, we get results. We exposed the Clinton email scandal. We exposed Benghazi. We exposed IRS. We're on top of the Comey scandal. We're getting court rulings still on Hillary Clinton's email scandal. She isn't going away. She's back. And we're going to hold her accountable, the State Department accountable, and all the other corrupt politicians, Republican and Democrat here in town, because this, as the president says, this swamp needs draining. And I would encourage the president to focus his administration on this accountability project that the Judicial Watch is leading, and target and tell his Justice Department to get on the ball in terms of stopping the obstruction of our FOIA litigation and the FOIA litigation of others. This lawsuit I was telling you about earlier, there's another conservative group that's suing with us, Cause of Action, and they do some good work. And I know there are other groups out there and individuals suing for information. So this is really outrageous. And before I go, there's news this week about how the FBI told a requester up in New York, who was a lawyer asking for records about the Clinton email investigation out of the FBI, they said, well, there's not enough public interest to justify releasing this information in light of Mrs. Clinton's privacy interests. So again, this is the FBI and Justice Department of President Trump protecting Hillary Clinton with this absurd argument that Hillary Clinton's privacy interests, which are nugatory, outweigh the public interest in figuring out what the heck went on with the criminal investigation or non-investigation into her email handling. Now, we've heard that before from this administration, too. I remember sitting in court a few months ago telling where they were, I think I told you about this last week, where Justice Department lawyers went in and said, we shouldn't have to turn over these emails quickly because there's diminished public interest in them, referencing the Clinton emails. So time and time again, they are defending Hillary Clinton in court, and the president ought to be outraged about it, and I hope he pays attention to it. And in the meantime, we're just going to keep on fighting and hoping we get court rulings that bring the government to heel under the rule of law. Thanks for joining us this week. I hope you have a great holiday weekend, and I hopefully see you next week.